joining us today. We proceed now to our first panelist for today, Ms. Ajoke Ojikutu. I would introduce Ms. Ajoke Ojikutu before we proceed to the question and answer question sessions. Ms. Ajoke Ojikutu is an associate partner and the head of corporate practice and commercial law practice at the law firm of Pinero LP. Prior to her role, she worked in the legal departments of Motora Chemical Industries PLC as a legal counsel, and also with the law firm of Judge Itobi and Partners. As part of her key projects and achievements, she has led a team of lawyers in advising West Power and Gas Limited on its multi-million-dollar acquisition of Eco Electricity Distribution Company. Please welcome Ms. Ajoke Ojikutu.
Thank you, KD. Thank you very much. So I'll just kickstart the whole topic for today. And what I'll be doing generally is just introducing us to what mergers and acquisition is all about, and then telling us what the legal framework that regulates M&As are in Nigeria. The concept of mergers and acquisition is such an intriguing one that you will agree with me that it has become a pivotal tool for economic development and growth, especially in today's commercial world. The concept is largely used for restructuring business entities. Companies usually use it to either, enter new markets, expand their operations, with a view to achieving growth, increase their revenue and profitability, sometimes also to reduce the cost or associated with producing a product or a service, simply by merging or acquiring another company. And in some instances, they have used it to survive, economic challenges and even to build stronger institutions. Just like Chief was telling us, due to the pandemic, most businesses are now looking for alternatives to survive. It would amaze you to find out that most businesses today, even though we're doing core different things, are looking into something else. Just the other day, I heard that Eco Hotel, which we all know is a hotel, is already doing things like laundry services and sending food to people. So obviously, we all have to, think out of the box in this time. So we're asking today, do we see mergers and acquisition as an alternative, to helping our businesses? Should businesses be thinking about merging or acquiring one, just so that, in order to scale up and just to survive these times? I guess the whole concept of mergers, in one way, some authors have tried to define it. A particular author defined it as a business combination, which involves the fusion of two or more corporate entities into a large one, usually on equal terms. On the other hand, an acquisition is simply the purchase of a company by another company of all of its substantial interest, and usually, and that requires an acquiring company. So it's basically one company acquiring the other, and usually becomes a subsidiary or a division of the acquiring company, which tells us basically that the process involves a buyer and a willing seller in most cases, except we're having a hostile takeover. Mergers and acquisition have largely been beneficial to the Nigerian economy. I mean, serious M&As in Nigeria were really started when CBN, in a bid to stabilize the Nigerian financial institutions, increased their capital ratio of banks in Nigeria from 2 billion to 25 billion naira, and literally gave them the permission to use corporate restructuring tools such as M&As as a way of meeting that requirement. So just to prevent them from winding up. Prior to that, there were other mergers, but it was really the banking sector mergers that really kicked off M&As in Nigeria. I mean, like one author put it, it was the banking reform of 2005 that was the bird that literally flew the kite for mergers and acquisitions in Nigeria. And it was that development that drew the attention of other sectors of the economy, to how important M&As are. I'm sure Debola will be telling us part of that, since that's where he's playing right now. It was reported, interestingly, that in 2018, Nigeria apparently had the biggest M&A market with about 59 deals worth $4 billion. And Chief had mentioned some of them that we all know: the acquisition of Olam's acquisition of Dangote Flour Mills, Coca-Cola's acquisition of Chi, MTN's acquisition of Visa Phone, and of course the one we all know happened last year, Access Bank and Diamond Bank. And I think before that we had the Polaris Bank acquisition of Skybank. So it's not new in Nigeria. Maybe we need to see more of it. So those are the sort of things we'll be exploring today. The key legislation governing M&As is the Federal Competition and Consumer Protection Act, which was enacted on the 30th of January 2020. Faced in Nigeria. The FCCPA, coincidentally, is also a merger on its own because initially what we had was a draft of the Federal Competition Commission Bill that was taken to the House but rejected. And then we also had the Consumer Protection Council Act. So the two are actually merged. So maybe it's a coincidence that this is the legislation now used to talk to enact and to legislate, review mergers and acquisition in Nigeria. So the two were merged. So the Consumer Protection Act was then repealed to now create what we now have as the Federal Competition and Consumer Protection Act. So it replaced the CPC Act.
Thank you so much, Ajoke. We're trying to keep to time. Thank you so much. The new Companies and Allied Matters Act 2020, are there any implications on mergers and acquisitions?
Okay, thank you, Katie. Just before I go into that, one of the things I was trying to finish up earlier is that prior to the FCCPA, the M&A regulatory framework in Nigeria was largely constituted by two primary legislations, one being the Investment and Securities Act of 2007, ISA, and the second one being the Companies and Allied Matters Act of 2004. So ISA was one that empowered SEC to literally review, approve, and regulate mergers up until the FCCPA stripped SEC on this role. It is important to note that both of them, the Federal Competition and Consumer Protection Act established a hierarchy between the the FCCPC, which is the commission, and any relevant government agency in a regulated industry, whereby the FCC takes precedence over and above any such relevant government agency in matters of mergers and business combinations. In addition to this, any regulation by SEC, by the CAC on mergers will also be subject to guidelines jointly issued by the FCCPC and the Securities and Exchange Commission. The new innovations on the new CAMA on M&As is based on a few factors. They introduced new things. For instance, under Section 711 of CAMA, the issue of arrangement or a compromise between two or more companies. Arrangement or compromise are also corporate restructuring tools that companies use either when they have any scheme of arrangement. Now, what CAMA did here was to empower the courts to order separate meetings of the companies. So if they decide to merge, each company will apply to the courts to have a separate meeting. This was not in the initial CAMA. And this allows, more or less in many ways, protects the minority shareholders, because now they can't say, oh, they were not aware of such a meeting. So the newcomer has given the courts the power to order separate meetings of the companies when they apply. And once they have done that, the whole of any part of those, the members of the company also represented at that time, they must have at least 3/4 in value of shares of the members present. In other words, they must sanction that meeting before they apply to the courts. So members of the company representing at least 3/4 in value of the shares of members being present and voting either in person or proxy at each of those separate meetings must agree to the scheme before the court can sanction it. Another introduction that is also key is also the application to a scheme or contract involving the transfer of shares in a company. So under Section 712 of CAMA, when a scheme or contract is being, so if two parties want to merge, or rather if a company wants to buy shares in another company, that company needs to have 9/10 in value of the shareholders' approval to be able to do that. So in other words, they have, is it 4 months within 4 months after the making of the offer, they must be able to agree and say that they'll take up the shares. After they've done that, they need 9/10 in value of the shares or shareholders' consent. Once they've done that, they then have an extra 2 months after that 4 months have expired to then give notice in the prescribed manner to any of the dissenting shareholders and to let them know they want to acquire their shares. So in some way, it was also to protect the dissenting shareholder. So if at the end of the day they agree, then they can then the shares are transferred. Another point, the newcomer or innovation that was brought in by newcomer is the issue of moratorium on creditors' voluntary winding up in a scheme of arrangements. So initially, what Section 717 is now saying that there will be no winding up petition or enforcement actions by a creditor, secured or unsecured. It will not be entertained against any company that has started the proceedings of an arrangement or a compromise with its creditors for 6 months. That means within 6 months, none of them can bring a petition or an enforcement against that company. Literally, it's to also in some way help the company so that you're not just killing off the company, you're allowing them within that 6 months to be able to decide what they want to do as opposed to what would initially happen. So now they can't do that. But there are exceptions to that rule where the secured creditors alone can go to the court and apply within 30 days to file for a discharge of that 6 months. Unfortunately, because of time, I can't go into that. Another innovation introduced was the issue of netting, which wasn't in the previous CAMA. So it says that there must be, if there's a netting agreement between the parties. So a netting agreement basically says you and I have decided to either forestall some form of payment or our agreement of the services to a future date. So if, for instance, I give you a service and we decide that payment will not be till about 8 months. So I've netted that payment. But what the newcomer is saying is that it does not preclude you, even if that party goes into liquidation, even if it's an insolvent party, whereby you or against the guarantor, you are still obliged to that agreement. You still have the obligation to disclose that you've gone into a netting agreement. I guess in the essence, for instance, if you're going to a merger with another company, that company is obliged to disclose that they have a netting agreement with another third party. Another innovation is the disclosure of significant control and beneficial ownership. Initially, beneficial interest was limited to, sorry? Okay, thank you. So I was just saying that the disclosure of significant control. Initially, the repealed CAMA had it for only public companies, but CAMA 2020 does not make a distinction between disclosure required by a public company or a private company. In other words, you need to disclose your beneficial interest, whether it's a private or public company. The threshold for substantial, also introduced a threshold for substantial interest. For acquisitions, there's a right of first offer and other restrictions. Provisions of financial assistance by a company for acquisition of its shares. Thank you.
Thank you so much, Ajoke. Quite enlightening. Ajoke, I do not know if you would like to shed more light on the due diligence checks that are necessary or that may be considered in an M&A transaction.
Katie, thank you for that question. Just like Dibala was saying, an M&A is like a marriage, between a man and a woman. It's two companies coming together. So before you even go into such an arrangement, you need to get to know each other. The key due diligence for an M&A, the first one will be a legal due diligence. So for instance, you need to know who the owners of the business are. What is the culture of the business, the profile of the business, the employees, the intellectual properties involved, technology. So the legal due diligence will require, of course, expertise, lawyers involved, to do some form of KPIs on the company, whereby you can tell that, is this a company we want to acquire? Is this something we want to go into? So you need to ensure that you're not only looking to projections of the company, you need to make sure they're not just, what's the word? projections that are not real. You want to ensure that this is a viable company that you're buying into or merging with. So the legal due diligence is key. The business profile, like I mentioned earlier, the ensuring that you know who the owners of the business are, the employees, ensure that the companies have no contingent liabilities, find out what litigations matters there, their material contracts, do a corporate search on the company so that way you can ensure that it is a company that is viable. And then you also must do a financial due diligence, because it's not enough to just see the statements as well. You have to ensure that the projections are right, tax liabilities that may be involved, the assets of the company are actually valued at the valuation that they really are. Also, there must be some form of technical due diligence, depending on what sort of company it is, especially now in view of the pandemic. If you're going into mergers and acquisition, you must know what sort of company you're buying into. I mean, we don't want to see things like what's going on now with, just recently, I don't know if you've heard of the story of Tiffany and Louis Vuitton. Now we find out that Louis Vuitton is even counter-suing, and most of the deal has gone wrong because one of the things they're now saying is the adverse material effect of COVID-19, the threat of the US tariffs on French goods, and the fact that Tiffany also had requested for an extension of the deadline. So you really need to come to the table, ensure that your agreement is watertight, ensure that there are condition precedents that both parties need to meet before they go into these mergers. And of course, if you're the company being acquired, it's okay to also do what we call a reverse due diligence. In other words, this company taking you over, can they actually afford us? Is this a company who would actually want to accept it's a hostile takeover? And even with that, we're seeing in America, for instance, where they're adopting clauses called the poison pill, where you can, after taking over buying shares, you don't get a discount to buy more shares from shareholders. So the whole idea of a due diligence is to ensure that you don't get into trouble. I mean, if you're merging, it's key that these things are taking note of. I believe it was John F. Kennedy who told the story of the Chinese, a Chinese story about the Chinese using 2 brush strokes to draw the word crisis. And one brush stroke was meant for, one brush stroke meant danger, and while the other brush was meant for opportunities. So I'll literally be telling companies today, if you're going into mergers and acquisition, have one stroke thinking of looking out for the dangers involved, and have the second opportunity and say, what are the opportunities involved in this? Thank you.
Thank you so much, Ajoke. Ajoke, could you tell us what you consider a successful mergers and acquisition?
Thank you, Katie. Well, like most of the speakers have said, a successful merger, well, in my opinion, there are pre, post, and key factors that can influence or attribute to what could be considered a successful M&A transaction. Clearly, one of them would be to ensure that both parties, come to the table, negotiate great terms. And like Debola said, the shareholders' agreement is very critical. And also what happens after a year or two, after they've gone into the mergers and acquisition, because we've seen successful ones who after 2 to 3 years then start having issues, or at the end of the day call off the deal. Like we're seeing with Tiffany and LV, and even more recently, cases here locally in Nigeria with like Healthcare and Health Plus, Chicken Republic, whereby they're having issues on the sort of acquisitions they've had, whether it's the numbers of, if there were conditions precedents not being met. So a successful one would definitely be one where both parties have agreed. There's been key disclosures. There's a successful mergers to ensure at least the employees are happy with it, the directors, the shareholders are also happy with it. I guess I believe that that would be considered a successful merger. Thank you.
Thank you so much. Thank you so much.